Hi everyone, today we're going to review Chapter 9. Chapter 9 focuses on confidentiality and informed consent. Alright, so to begin, some brief background. So confidentiality refers to the obligation of the healthcare provider to maintain patient information in a manner that will not permit dissemination beyond the healthcare provider. From its origin in practice to its development into legal protections, the concept of confidentiality has served to protect patient-specific health information from disclosure. Not only have those involved with direct patient care served to protect health information, but health information managers and directors have assumed responsibility for protecting confidential patient-specific health information. The demands for information arise not only from third-party payers and governmental entities, but also from patients themselves when deciding to consent to or forgo treatment. This demand for information has initiated a significant development in the relationship between law and medicine, which is the doctrine of informed consent. To understand the responsibilities that confidentiality and informed consent place on healthcare providers, health information professionals must understand the historical development of each concept. In this chapter, we'll examine the legal basis for confidentiality and the scope of informed consent. When addressing issues of confidentiality of patient-specific health information, the focus rests on the relationship between the patient and the healthcare provider. Through this relationship, the patient imparts to the healthcare provider information that will assist him or her in diagnosing and treating the patient's symptoms. The dialogue between the patient and the healthcare provider is beneficial in two respects. The healthcare provider gathers the data needed to make informed diagnoses and treatment decisions, and the patient provides the necessary information without fear that it will be disseminated beyond the healthcare provider. The obligation of the healthcare provider is to maintain the patient information in a confidential manner and as old as medicine itself. The oath of Hippocrates, written centuries ago, states, "What I may see or hear in the course of the treatment, or even outside the treatment, in regard to the life of men, which on no account one must noise abroad, I will keep to myself, holding such things shameful to be spoken about." The Hippocratic Oath has served as the foundation of the current medical profession's guidelines on the confidentiality of health information. In light of developments, society has recognized the need for more professionalism to protect patient-specific health information. The underpinning to legal protections for patient-specific health information is the patient's right to privacy. This right to privacy is sometimes referred to as the right to be let alone and other times as the right to control personal information depending on the source of law on which the right is based. We'll discuss the following source forms from the Foundation for Rights to Privacy that include constitutional provisions, statutory provisions, and common law provisions. While the right to privacy is not explicitly listed in the Constitution, the Supreme Court has held that a fundamental right to privacy exists. Although the scope of the privacy right has never been clearly defined by the Supreme Court, the court has applied it in the context of health information. In Whelan v. Roe, the Supreme Court examined the right to privacy in the context of New York State's effort to collect a computerized database concerning the use of certain drugs labeled as dangerous and likely to be abused. Under New York law, physicians were required to report to the State Department of Health patient's name, age, and address, the names of the pharmacy and physician, and the dosage of the drug if one of the listed drugs was prescribed. Several groups representing patients who had received the prescriptions and two physicians' associations challenged the law on grounds that it invaded the patient's privacy. In determining whether the reporting requirements amounted to a constitutional violation of the right to privacy, the court applied a two-prong analysis relating to the patient's interests. The first, a non-disclosure prong that recognized the individual's interest in avoiding disclosure of personal matters, and two, an individual autonomy prong that recognized that individual's interest in independent decision-making. The court recognized that both patient interests existed and then balanced these interests against the state's interest in deterring drug abuse and the safeguards implemented to protect the information from subsequent disclosure. On balance, the court concluded that the public's need for information outweighed the individual's privacy interests. While specific to the facts of the case, the Whelan decision is significant for the fact that the Supreme Court recognized in it a right to informational privacy. This right to privacy has been recognized at the state level, with some states providing more explicit constitutional privacy protections than that of the federal government. Central to the federal government's efforts have been the Freedom of Information Act and the Privacy Act of 1974. Both laws apply to governmental record-keeping activities and do not focus on the activities of the private sector. The Freedom of Information Act encourages access to government records and mandates disclosure upon request, absent an exception listed in the statute. By contrast, the Privacy Act presumes that certain information is confidential and may not be disclosed unless there is a written consent of the individual. In the healthcare arena, these provisions come into play in the context of data that's held by the Social Security Administration and the Department of Health and Human Services. Both executive branch agencies release information that's held by them for purposes of research and statistical studies. When releasing these data, the agencies abide by the statutory provisions listed and include removing patient identifying data. Confidentiality protections at the state level fall into three categories. The first, open record statutes. The second, privacy statutes. And the third, physician-patient privilege statutes. Let's talk a little bit about open record statutes. So open record statutes generally apply to records that are held by a state agency and correspond with the principles of the Freedom of Information Act. A presumption of disclosure absent a statutory exemption. Privacy statutes generally correspond with the principles of the Privacy Act, a presumption of confidentiality which may be rebutted with evidence of patient authorization to disclose information. Privacy statutes at the state level may impose fines upon healthcare facilities that breach confidentiality and allow for fines to be assessed for each unauthorized access to confidential patient information. The physician-patient privilege applies to the introduction of evidence at trial and is used to prevent the forced disclosure or testimony about information that's obtained by a healthcare provider during the normal course of treatment. The privilege exists to encourage the patient's disclosure of relevant information to the provider, no matter if the information is of an embarrassing or humiliating nature. The privilege applies to both governmental and private sectors and is generally held to rest with the patient, but it may be asserted on the patient's behalf by the provider to prevent forced disclosure. Common law protections of health information are essentially recognized that individuals' right to bring a lawsuit for damages or injunctive relief against one who inappropriately obtains, discloses, or uses patient-specific health information. Examples of lawsuits of this type include actions for invasion of privacy claims, defamation, and breach of contract. Each of these lawsuits was previously described in Chapter 4 when we discussed the principles of liability. The terms privacy and confidentiality are terms that people do use loosely. interchanging them as though they possess the same meaning. The definitions indicate they're separate but related concepts. It is helpful to distinguish between these terms by referring to privacy as a right of belonging to the patient and confidentiality as a duty belonging to the healthcare provider. Alternatively, one could view privacy as the patient looking inward, protecting information that belongs to him or herself, and one can view confidentiality as the outward-looking activity of the provider to not disseminate information that belongs to another, being the patient. The HIPAA privacy rules defines confidential health information as protected health information, or PHI. The health information that's considered protected under HIPAA contains identifiers by which an individual can be recognized. These identifiers include name, address information, dates that include birth, death, admission, discharge, or any other data that indicates the individual's age, telephone number, fax number, email addresses, health record number, social security number, account numbers, vehicle identifiers, IP addresses, facial photographs, biometric identifiers, and any other unique identifying number, characteristic, or code. Numerous restrictions are placed on individually identifiable health information under HIPAA. The information that is stripped of all identifiers that was previously mentioned that could be used to identify an individual is referred to as de-identified health information. Without the authorization, information must be de-identified prior to release or disclosure. An H9 professional possesses an ethical obligation to protect a patient's privacy and the confidential information that's contained in the patient's health record. In response to the increasing demands, the HIPAA privacy rule requires that all providers issue a notice of privacy practice to each patient. Now, the notice of privacy practice is important, and I have seen it on numerous practice RHIT exams. What the notice of privacy practice is it's a notice that informs the patient of the healthcare provider's duties concerning PHI, including how the provider may use and disclose it, with whom they will be shared, and the safeguards in place for the PHI. The notice also informs the patient of his or her rights under HIPAA, such as the right to an accounting of any disclosures of their PHI and the right to complain if they feel that their privacy rights have been violated, along with the name and phone number of a contact person with whom they can lodge a complaint. In addition, the privacy rule requires that a provider informs the patient that the disclosures, other than for treatment, payment, or operations, will only be made with patient's consent. The privacy rule also requires a provider to make a good faith effort to obtain the patient's acknowledgement that the notice has been received. Finally, the privacy rule requires the covered entity to post a complete copy of the notice in a clear and prominent location of their facility. The HIPAA privacy rule does not stop with protection of the patient record per se, but forms the basis for protections related to the electronic health information exchanges. The nationwide privacy and security framework for electronic exchange of individually identifiable health information issued by the U.S. Department of Health and Human Services addresses privacy and security challenges related to these exchanges. The framework is based in large measure on the HIPAA privacy rules, and there are 8 principles that comprise this framework. The principles include individual access, correction, openness and transparency, individual choice, collection, use, and disclosure limitation, data quality and integrity principles, safeguards, and accountability. Electronic health records pose challenges to maintaining the confidentiality and privacy of PHI. HIPAA requirements include the implementation of electronic health record and the expansion of the electronic health information exchange efforts that have influenced HIM professionals to expand their responsibilities for confidentiality and privacy in the recent years. Instead of viewing the protection of health information as it relates to a set of paper-based patient records, health information managers now view privacy protection from an enterprise-wide perspective. Health information found in the electronic setting and other related database requires the use of computer data security programs to address confidentiality and privacy concerns. These changes will continue to widen and influence the responsibilities of health information professionals for the years to come. Although all states consider health information confidential, to some extent the need to protect greater protection to health information concerning the HIV status and AIDS has been legally recognized in the majority of states. As a general rule, HIV and AIDS confidentiality statutes place restrictions on identifying both the patient tested and the test result. Disclosure of a patient's identity or the test result may be made only subject of the test or her legally authorized representative. A person designated in a legally effective release of information, the healthcare provider's staff directly involved in patient care, or the appropriate public health authority. There are also professional guidelines that guide the actions to include the standards of conduct and that they could be used to establish the standards of care. Patient death. When a patient dies, they're obligated to keep HIV information confidential. Confidential does not end. Ethical guidelines have also been introduced from the AMA when to include HIV and AIDS information on the autopsy report. Among the most significant developments in the relationship between law and medicine in the 20th century is the doctrine of informed consent. From its origins in the right of privacy, this doctrine has developed into an integral part of a relationship between a healthcare provider and the patient. It has also served as the basis for federal regulations that govern research involving human subjects and is reflected in consent forms that are used by providers before treatment is rendered. Informed consent is deeply rooted in the ethical concept of autonomy. It requires that healthcare providers disclose adequate information to patients and ensure that the patients understand the information that is being provided to them. Power is placed in the competent patient to act voluntarily, make decisions regarding the extent of care. In traditional application of battery theory, not an adequate basis for related lawsuits. By grounding the informed consent doctrine in negligence, courts necessarily place the focus on the healthcare provider's duty of due care. As developed by the courts, the informed consent doctrine places a duty on healthcare providers to not only obtain consent to treatment, but also to disclose to the patient in an adequate manner the nature of the treatment or procedure, the risks involved, and any available alternatives and the benefits that could be reasonably expected as a result of the treatment or procedure. The healthcare provider's failure to discharge the duty to disclose sufficient information to the patient before treatment, accompanied by harm to the patient, resulted in finding of liability for negligence. The scope of the informed consent doctrine can be measured in several ways. Who may consent to the treatment, how much information the healthcare provider must disclose to the patient, and what situations require informed consent. The scope of the informed consent doctrine is illustrated in this diagram below. As a general proposition, it is the patient and the patient alone who decides whether to consent to or forego treatment. This general proposition assumes two things. The first, that the patient is competent under the law to consent to treatment, and second, that an emergency situation is not present. Adult patients are presumed competent absent an adjudication of incompetency by a court law. For those patients whom legal competency is clearly an issue, for example, minors or patients who are comatose, the law provides that an authorized person may consent to or forego treatment on the patient's behalf. Referred to as substitute consent, the process allows a healthcare provider to provide treatment to the patient when the patient cannot provide consent to treatment. In the minor context, substituted consent given by parent or legal guardian will apply until the minor reaches the age of majority or becomes emancipated in the eyes of the law. Examples in which emancipation would provide legal authority for the minor to give consent include marriage, childbirth, or entry into the armed forces. When certain medical conditions are present, state laws may provide for the minor's consent even if majority or emancipation requirements are not met. Examples of special medical conditions include pregnancy, sexually transmitted diseases, and substance abuse. When speaking of legally incompetent patients, the focus rests on the patients who were either never competent or were once competent but subsequently became incompetent due to illness or accident. Often, consent issues in this context involve the question of whether the patient or someone acting on the patient's behalf has the right to refuse treatment with the result that the patient may die. This is commonly referred to as the right to die. This issue has been present in healthcare for decades. There's a court case called Cruzen versus Director, Missouri Department of Health, and it is responsive legislation that the country focused on the so-called right to die issue. In Cruzen, the Supreme Court addressed whether life support could be withdrawn from Nancy Cruzen, a patient in a persistent vegetative state due to a car accident. The court determined that Missouri's requirements of showing of clear and convincing evidence of Nancy's wishes indicating that she wished life support withdrawn before the healthcare provider withdrew treatment was not unconstitutional. Focusing on this case led to the passage of the Patient Self-Determination Act, the PSDA. The goal of the PSDA is to ensure that a patient's rights to self-determination in healthcare decisions be communicated and protected. It requires that the healthcare providers who are Medicare or Medicaid certified inform patients of the status of state law governing a patient's right to make advance directives for accepting or refusing healthcare services, and healthcare providers' written policies concerning implementations of the patient's rights. Advance directives are defined as written instructions that are recognized under state law. It includes things such as the living wills or a durable power of attorney for healthcare. It relates to the kinds of healthcare that a patient wishes to have or not have when incapacitated. A living will is a document that's exercised while a patient is competent. It provides direction to the medical care in the event that the patient becomes incapacitated or unable to make personal decisions. A durable power of attorney for healthcare is a document that allows a competent patient to name someone else to make healthcare decisions in the event that that patient becomes incapacitated or unable to make personal decisions. Although the PSDA places obligations on providers to educate and communicate with patients, staff, and the community, it does not create or modify any substantive legal rights. Each state possesses the authority to create or modify substantive legal rights that concern advance directives. In most states, statutes address substantive legal rights grant permission to patients to use living wills, durable power of attorneys for healthcare, or both. A living will refers to the document that provides the direction to medical care in the event that the patient is incapacitated or unable to make personal decisions, whereas the durable power of attorney is for the healthcare allows a competent individual to name someone else to exercise healthcare-related decisions on their behalf when certain conditions are met. What is significant about the interplay between federal and state law in this context of advance directives is that state law addresses patients' substantive rights, whereas federal law addresses the procedures by which those rights must be exercised when the patient receives treatment from a healthcare facility. HIM professionals should be aware not only of the PSDA, but also of the fact that the U.S. Department of Health and Human Services has issued implementing regulations to the PSDA, and that the Joint Commission and DNV Healthcare have issued standards that address advanced directives. Health information professionals should realize that the substantive legal rights governing advanced directive have 51 possible variations covering each state and the District of Columbia. Emergency situations pose difficult problems in obtaining a patient's informed consent. An emergency situation, if it's presented when the patient is unable to give consent, another person authorized to give consent on the patient's behalf is unavailable, and a delay in treatment would likely result in death or serious harm to the patient. Examples of emergency situations where informed consent may be difficult, if not impossible, to obtain include instances in which a person suffers sudden injury and any delay in treatment may result in increased risk to life or health, and which a patient who is undergoing treatment for a non-emergency condition experiencing a worsening of the condition to the point that the patient's life is threatened. State legislatures and courts have recognized that healthcare providers confronted with these situations risk potential liability and have created legal protections for them. The legal protections are commonly referred to as the Good Samaritan Law and serve to protect providers, rescuers, and private citizens from liability for unauthorized treatment, as opposed to protection from rendering negligent treatment or intentional misconduct. To the extent to which information must be disclosed to the patient essentially rests with the question of whether the patient receives sufficient information from which to make an informed decision. Now, what constitutes sufficient disclosure is a matter of state law. Generally, sufficient disclosure includes information concerning the nature of the proposed procedure or treatment, the risks involved, if there are any available alternatives, the benefits that may be expected. Now, states are split in their approach to measuring the duty of disclosure. Disclosure is measured under the law from two different perspectives of a healthcare provider and patients. Frequently, it's referred to as the professional disclosure standard. This standard measures what a reasonable provider under the same or similar circumstance would disclose. Under this approach, expert testimony would be required to establish parameters of the standard. Many states have adopted this standard by statute or case law. The second approach looks to the needs of the patient rather than the professional standards of the healthcare provider. Here, the reasonable patient standard measures what material information is necessary for an average reasonable patient to reach a decision to consent to or to forego treatment. Because it is this patient's perspective that is measured, it is unnecessary to produce expert testimony concerning the standards of practice. Several states have adopted this standard either by statute or by case law. Absent an emergency situation, any treatment that is rendered by a provider involves consent of a patient. This consent can either be implied or expressed. Now, implied consent exists in situation in which a patient voluntarily submits to a procedure with apparent knowledge of that procedure and the procedure presents slight or no risks, such as taking the patient's pulse or temperature. In these instances, the law presumes that the patient has given consent. Express consent, on the other hand, of the patient is to form of verbal or written informed consent. It's necessary in cases where diagnostic or therapy procedures will be performed. In express consent, the risk of harm may or may not be readily apparent to the patient, but is generally considered to be more than slight. Examples here include invasive surgery, radiological therapy, or procedures that may change the body structure. Now, at this time, we have completed all of the material that we'll be discussing in Chapter 9, the confidentiality and informed consent. I encourage you to review this chapter in detail, and please reach out to me if you have any questions. Thank you.